The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. The Fourth Amendment is triggered when there is a search or seizure by the government, which typically means the police. But the Fourth Amendment applies to any government agent. It does not apply to your nosy neighbor or friend who looks through your home. A thing is searched when there is a trespass to persons, houses, papers, or effects. At its most basic form, the amendment is about situations when the government intrudes upon a person's property. Beyond this, however, the Supreme Court has recognized situations where a person reasonably expects privacy. For example, you have a reasonable expectation of privacy in a public restroom, but not in a public street. A thing is seized if the government takes it. A person is seized if a police officer applies force or makes a show of authority that is followed by submission to that authority. Once triggered, the Fourth Amendment requires reasonableness. A search or seizure must be reasonable for it to be constitutional. What makes it reasonable? If there is a warrant or an exception applies. Generally, the government needs a warrant to conduct a search or seizure. A warrant is a legal document issued by a judge to authorize this power. For a warrant to be properly issued, it needs to be based on probable cause, issued by a neutral and detached magistrate, and described with particularity. Probable cause is the fair probability or logical belief that a crime has been, is being, or will be committed, based on objective facts and circumstances. The judge issuing the warrant cannot be part of the investigation, or otherwise so connected to it to question their judgment. And the place to be searched and person or things to be seized needs to be described with particularity, to limit the government from searching anywhere or seizing anything or anyone. If the government does not have a warrant, but still carries out a search or seizure, it may still be reasonable if an exception applies. Here are some of the most used exceptions. Consent. If a police officer gets permission from the individual whose person or property is being searched or seized, then there is no need to get a warrant. However, the permission must be given voluntarily. The police must not coerce the person into giving consent. Plain view. If an officer sees something obviously incriminating, where the officer is legally allowed to be, the plain view exception allows them to seize the evidence. Crucially, the officer must have legally been at the vantage point, and the incriminating character of the object must be immediately apparent. SITLA, Search Incident to Lawful Arrest. This exception allows an officer to perform a warrantless search of an arrested person and the area within the arrested person's immediate control. The reasoning behind this is for officer safety and to preserve evidence. The vehicle exception allows the search of a vehicle if the officer has probable cause to believe that evidence is in the vehicle. The reasoning behind this exception is to keep evidence from moving away because of how mobile vehicles are. The idea being that if we make officers get warrants, the car could be long gone by the time they get it. Terry Stop and Terry Search, named after the landmark case Terry v. Ohio, which established this exception. This is an exception to the warrant and probable cause requirements. So an officer doesn't need to get a warrant, nor do they need to have the highest level of suspicion. The officer needs only reasonable suspicion, more than a hunch, but less than probable cause. Reasonable suspicion is based on articulable individualized facts that show that criminal activity is afoot. If the officer has reasonable suspicion, they can briefly stop the person to investigate for the purpose of confirming or denying the reasonable suspicion. If the suspicion is dispelled, the seizure must stop. The officer may also perform a cursory protective inspection based on reasonable suspicion that the person is armed and dangerous, again to confirm or deny the suspicion. This means a quick over-the-clothes pat-down to check if the person has a weapon. So what happens if there is no warrant and no exception applies, and the government performs an unconstitutional search or seizure? That's when the exclusionary rule applies. Illegally obtained evidence cannot be used against the person whose rights were violated, thus incentivizing police officers into gathering evidence properly. So let's review. The Fourth Amendment applies when the government searches or seizes. Once triggered, the Fourth Amendment requires reasonableness, which means a warrant or an exception. A warrant must be based on probable cause, issued by a neutral and detached magistrate, and the person, place, or thing to be searched or seized must be described with particularity. Some exceptions include consent, plain view, vehicle exception, and the Terry stop and search. If the Fourth Amendment is violated, the evidence is excluded from court.